Hey, gun people. Well, it's the start of the trial. This is the last day of the trial, and they're having a discussion about whether or not he's going to testify. Now, I don't know if he is or he isn't. My guess is he isn't, but I only listened up to the part to where he says, you know, I've told you it's your choice and blah, 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 blah. So I don't know where this is going or why. I'm sure the jury's not in here, but they are on the record. So let's hear how this turns out.
Mr. Chauvin, you and I have had several discussions throughout the course of my representation of you relevant to your right to testify or to choose to remain silent, correct?
That's correct.
And during the course of our representation, it's fair to say that you and I have had this conversation multiple times, correct?
Correct.
You understand that you have a Fifth Amendment privilege to remain silent? Do you understand that?
Yes.
You understand that if you choose to exercise that right to remain silent, neither the state nor the court can comment on your silence as a sign or an indication of your guilt? Meaning they can't say, he didn't get up and defend himself, so equate your silence with guilt. Do you understand that?
Yes.
Okay. They can't say that he took the Fifth, but they can imply it in closing that this is all the information we have since, well, it's pretty, I've seen some lawyers get it in that we haven't heard from the defendant's side, or the defendant didn't tell us anything different, or something, some of those comments. Now, maybe they've changed it over the years to where they can't do that anymore, but I've seen attorneys slide it in. They can't go. You notice that the defendant didn't get up on the stand and say he wasn't not guilty. You notice you can't say that because that's direct. But I do think they will slide it in a little bit, and there's always that worry that somebody on the jury is go, if you're innocent, why didn't you take the stand?
All right. Now, you also understand that you can waive that right and testify. Do you understand that?
Yes, I do.
You understand that if you chose not to testify, or if you did in fact testify, you would be subject to cross-examination by the state of Minnesota.
Yes.
You understand that if you were cross-examined by the state, we could not attempt to limit the scope of your testimony. The state would be given.
I almost think he's doing this because Chauvin wants to testify. And he's getting on a record, so it's not bad on his counsel that I've told you it's your decision, blah, 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 I can't control. He's given him all the options. The only thing he did say, so I don't know if he already said it or if I listened to it earlier, up to a certain point, he said, and I have not advised you either way, or something to that effect. I'm kind of surprised that I think he should say, I advise you not to testify. I don't think it's a good idea. And I've seen what the government can do when they get you up there, and they can make a mountain out of a molehill and trick you up. And it only takes one misspoken word by you and you end up in prison. So I'm advising you not to testify. I'm surprised he didn't say that. And maybe he does later, but he didn't say it from the point I listened to.
Broad latitude to ask you questions. Do you understand that?
Yes.
We've had this conversation repeatedly, correct?
Correct.
I have repeatedly advised you that this is your decision and your decision alone, right?
Correct.
I have advised you, and we have gone back and forth on the matter, would be kind of an understatement, right?
Yes, it is.
But after a lengthy meeting last night, we had some further discussion, agreed?
Correct.
And have you made a decision today whether you intend to testify or whether you intend to invoke your Fifth Amendment privilege?
I will invoke my Fifth Amendment privilege today.
Good deal. I think that is a smart move. Now, it's smart if he doesn't get convicted. If he gets convicted, someone will say that was a dumb move. He should have took the stand. But again, the government, you saw they pulled out all the stops. You have no idea what the government is holding. I mean, he could have in the third grade, stepped on a dog's paw and somebody said he kicked it, and they would bring that up. So you have no idea how the government can dig up shit or make up shit or ask you questions that sound like shit if you get up on that stand, because it's all bars off. They can do whatever they want. You decided to take a stand, you got the right to take the Fifth Amendment. So, and somebody said, and I don't know if this is true, maybe somebody can quote me something in the comments that knows for sure. I thought if you invoked your Fifth Amendment, you couldn't pick and choose answers. Now, they were saying, earlier the judge said Hall could pick and choose on what he went to the Fifth on. And somebody commented, only the defendant has to do all or nothing. And that's usually what I'm dealing with. And that's why I guess I thought everybody was all or nothing. I don't think I've ever seen a witness get up there and pick and choose what part they're going to play the Fifth on. You either plead the Fifth or you talk. Those are your options. And somebody said that's only applies to the defendant. If somebody could give me a case law or where that's at, that'd be great. Anyway, here we go.
Mr. Short, I'm going to address you directly because the decision whether or not to testify, I'm going to take this off, is entirely yours. In other words, it's a personal right. Mr. Nelson makes a lot of the decisions in trial, but one he cannot make for you is whether or not you testify. And he can give you advice, and you can take that advice or reject that advice. But the decision ultimately has to be yours and not his. Is this your decision not to testify?
It is, Your Honor.
All right. Do you have any questions about your right to remain silent or to testify on your own behalf?
Not at this time, I don't.
All right. Does anyone promise anything or threaten you in any way to keep you from testifying?
No promises or threats, Your Honor.
Do you feel that your decision not to testify is a voluntary one on your behalf?
Yes, it is.
Now, in addition to that,
So what the judge is doing now is he's trying to get away all the appealable things. These are things that people have appealed on, saying, I was threatened, or I didn't know, or it wasn't clear, or I thought, and then they'll try and put an appeal that he wanted to testify, but for some reason he didn't. So what the judge is doing is checking all the boxes for the appeal, saying, hey, you can't say this because I asked you. You can't say this because I asked you. You can't say this because you agreed. And that's kind of why this is happening right here.
Convinced then that this is your personal decision and that you're aware of your rights, but there is a jury instruction that may be read to the jury. This again is the one that you get to weigh in on. It's not for your lawyer to make the decision. Again, he can give you advice, and I don't want to know what the advice is, but you can accept the advice or reject the advice as to whether or not to give this instruction. If you would like, I can read this instruction to the jury. It's titled Defendant's Right Not to Testify. The state must convince you by evidence beyond a reasonable doubt that the defendant is guilty of the crime charged. The defendant has no obligation to prove innocence. The defendant has the right not to testify. This right is guaranteed by the federal and state constitutions. You should not draw any inference from the fact that the defendant has not testified in this case. Do you understand that instruction?
Okay, so I'm thinking the attorney told him, you want to say, yes, I want that read to the jury. Because that reinforces, in case any of them are thinking that, you didn't testify for some other reason. His attorney may say, I don't want that read to the jury because then it brings attention that you didn't testify. So let's see how this plays out.
Yes, Your Honor.
Would you like that read to the jury?
Yes, Your Honor.
Have you had enough time to talk to Mr. Nelson about whether that's a good idea or not?
I have, Your Honor.
All right. And so I will read that to the jury on your request.
Thank you.
All right.
Okay. And I kind of agree with that. I think it should be read because a lot of juries will just have, TV, oh, he didn't testify, he must be guilty. Whereas when they hear this jury instruction, and they get a lot of jury instructions. I hope they go over all the jury instructions because it's crazy. And, what this law is and what the elements of this. And if you find guilty, you must find blah, blah, blah. And if you find not, the jury instructions are like crazy. So I hope they go over all the jury instructions because they'll go over jury instruction on what force is, on what reasonable is, on what a reasonable officer. I really hope they go over them, but let's see.
Anything else regarding the defense case before we proceed to talk about rebuttal? All right, we'll have you rest in front of the jury then, and we can actually take the microphone back as well. Thank you. Thank you. We'll have you rest in front of the jury, Mr. Nelson.
Oh, shit, the defense is over already. He's going to rest. Wow. So that's why they had to cover this up. I didn't know that I thought he had another witness, and they just decided to do this morning. They're doing this because the defense case is done. So there's no more witnesses, and now this is where the government, the state's going to come in and cry about the mean doctor, even though they paid 3 doctors to say what they wanted to say. They're going to cry that this doctor said something that wasn't true and impugn one of their doctors, and they have to bring their expert back in order to clear it up, and it's not fair, and Your Honor, you have to give us it's not fair to the jury if they get, and they're going to, I guarantee you, they're going to get to call one of their doctors or some sort of rebuttal to this doctor witness because they know the defense's doctor witness hurt their case. But we'll see if I'm right.
With regard to the state's rebuttal, it's my understanding that the state is going to call a rebuttal witness. Is that correct? Okay. Whoever's going to speak to this, if we can kind of outline the topics and if you wanted to address formally.
Okay. If the defense lets them start replaying videos and all, it's a big mistake. He needs to fight this as hard as he can because the government is going to look at this. Once the government gets their greedy little fingers in anything, that they're just going to go buck wild. So if they get a rebuttal witness, you can bet they're going to repeat their narrative. They're going to repeat their lies. They're going to repeat those videotapes. They're going to show that one damn picture of him kneeling on his neck 14 times. They are going to put on a whole new case on this rebuttal. So I hope that they really limit the rebuttal to very specific points.
The decision regarding this newly discovered evidence. Sure.
just said newly discovered evidence. That's a whole bucket of worms in itself. In order to get newly discovered evidence in, you have to prove that it's new, because a lot of attorneys, DAs, especially the government, will hide shit until the end because they don't want to discover it, and they don't want to give the defense a chance to prepare a good defense against that evidence. So they will kind of like miss it, and then right near the end of the trial, when the defense doesn't have much time, they'll go, "Oh, we just discovered this, Your Honor, look." And now the defense doesn't have a lot of time because we're in the middle of a trial. We got a lot of things. We're on a time schedule. So a lot of judges won't let it in. But for some reason, it looks like this judge is going to let in newly discovered evidence. It'll be interesting on how this newly discovered evidence was discovered and how critical it is and how it was missed and why it wasn't discovered earlier. I'm not sure if the judge is just reading this.
Mr. Blackwell?
Good morning, Your Honor.
Good morning.
Counsel.
I was told in chambers that there was some newly discovered evidence that the state wished to present in rebuttal regarding carbon monoxide testing. Would you tell me what that was?
Yes, Your Honor. We have blood gas evidence from Hennepin County that would contain blood gas readings for the carbon monoxide content in Mr. Floyd's blood on May 25th, 2020.
And why didn't you have this before? If I was a judge, I would not let this in. I'm not going to let you drop something on a defense because of your incompetence if this was already available. Now, if they just went back and retested, that's different. But if they had this the whole time and they didn't discover it and they go, "Oh, we missed it, Your Honor, but now we found it," that's bullshit, DA, crooked lawyer shit.
All right. And when was it discovered? How was it discovered? Why
It
was
was-
it not disclosed earlier?
It was discovered yesterday by Dr. Baker. And what had precipitated it, Your Honor, was a piece of new evidence. It was a disclosure that came from the stand during the testimony of Dr. Fowler. And I want to show Your Honor exactly what it was. It was in one of the slides that Your Honor can see here if I adjust the camera. And where from the stand in the slide that Mr. Nelson prepared sent. Now, that was a new opinion. The word carboxyhemoglobin could have increased by 10 to 18%. Now, that was a new opinion. The word carboxyhemoglobin does not appear in the 31 pages of Dr. Fowler's report at all, nor a discussion about the carboxyhemoglobin content in his blood. Now, the concept of carbon monoxide was raised in the report, but not blood gas issues related to it. It was sort of discussed in the same context of sort of taking drugs through the rectum and other things that were raised generally, but not a specific reference to the carboxyhemoglobin content in Mr. Floyd's blood. Dr. Baker heard the testimony, had not himself ever requested this, nor had the ER physicians. They explained that when somebody's brought in and blood gases are taken, there's a panel of them that are taken.
So what it sounds like is their expert was watching this expert so he could give his expert advice behind the scenes to the DA, saying, "Hey, I think this guy got this wrong. I think you can fight this. I think this. Oh, you know what? I never heard of that. Let me follow up on this." So that sounds like how this was discovered, but I still don't know whether they had this. If they already had that information and they didn't bring it up, man, that's iffy, because now the defense brought it up and he opened the door. And so does the prosecution, since they have it, but they didn't know they had it and they weren't going to admit it and they weren't going to use it, but since the defense brought it up and now they do have it, I think the judge might allow it, but we'll see.
The ones that get generated in the records would be the ones that the ER physicians actually request. Nobody requested carbon monoxide readings because they didn't see how that was relevant, frankly. And no one had until this testimony yesterday that was specific to the carboxyhemoglobin content of the blood and set it at 10 to 18%. Now, Judge Cahill, what everybody did have access to would be the flip side of the equation. There was information on the arterial blood gas content that showed the oxygen saturation content in Mr. Floyd's blood, and the oxygen saturation was at 98%, which meant necessarily, to the extent there was any carbon monoxide in the blood, it would be at most 2%. This was the takeaway that Dr. Tobin had yesterday from this new disclosure, and we disclosed that to counsel, that would be something that Dr. Tobin could address based on information that everybody did have available. Dr. Baker simply then addressed the flip side of it. Was there a reading or measurement specifically on the carbon monoxide in light of this testimony from Dr. Fowler from the stand yesterday on the carboxyhemoglobin content and the slide which Mr. Nelson introduced?
Well, let me clarify one thing. When was the test actually run?
It was run the night of May 25th when George Floyd was brought in.
And you did subpoena all the records of Hennepin County Medical
We
Center.
did subpoena all the records.
And what?
So you had this, and you didn't make the point. I mean, I think, you know what? They should have brought that up on cross when they had him up there. Why should they get a rebuttal on that? Why don't you just call back the defense expert and have them give them a second bite at the cross limited to this thing and say, would it surprise you if his blood levels were at, or his oxygen level was at 98%? Wouldn't that indicate that the carbon monoxide was less than 2%? And let him re-ask the expert. Why bring in a second bite and all this other crap? I don't know how this is going to go.
They provided to you did not have that in it?
That's right, Your Honor.
Did Dr. Baker spontaneously call you to tell you that there might be something deep within the computer records that
Yes,
was
Your
not
Honor.
disclosed? Or did you seek him out and ask him for his?
We did not seek him out to ask anything. He had heard the testimony and thought that this record might exist.
The reason why that's important, because if they're out there seeking him out and asking, now they're doing an investigation and they've discovered this after the trial, and the judge may go, you know what? You should have done that before. You should have done your investigation before the trial. I'm not going to let in. But if they say the doctor heard it, which normally they wouldn't do, because it's televised, he can watch it, and now the doctor volunteered and came to them, it's almost like if some witness had some information that they didn't know and they suddenly saw this trial and they showed up and went, hey, I was there. I'm a witness. And they go, holy shit, we need to contact you. Where were you? How come we didn't find you? Why didn't you come earlier? Then they could try and get that witness in saying, hey, we didn't know. It wasn't due to our negligence. This person walked in, volunteered that they saw something that we had no idea. This is new evidence. We want to admit it. That would probably fly. So I don't know if this is going to fly or not.
Because he thought that, well, he was aware that there's a panel of the tests that are run by the machine, and then those that would go to the ER physicians would be the ones that they request to see the values on. So, but we did not contact him. It was the other way around.
And we're talking about carboxyhemoglobin readings. Is there also anything as part of that specifically about carbon monoxide concentrations?
Yeah, the carboxyhemoglobin reading would show the carbon monoxide concentrations, Your Honor, in the record, which has my markings on it. But it would return a value for the carbon monoxide content, and it would show whether or not that result is in the normal range or not. And that would be the reading in the readout from the test results.
All right. And so it specifically say carbon monoxide.
Well, it gives the letter symbols for it. So it would, if there's a clean copy,
What specifically does it say? Maybe you could just read it off the record.
it says specifically in the oximetry values, it says FCO and then H lowercase b, 1.5%, and then it gives the normal range of 0 to 2.0% as the normal range. It indicates on the record also a name for Mr. Floyd. For this record, it would be last name Bronze and first name Tennessee, because at the time the tests were run, they didn't know that it was George Floyd.
I note on Dr. Fowler's report that was disclosed to the state in February that on page 15 at the top it says, if there's a defect in the vehicle, this gas will be present, or if a person is close to the exhaust. For completeness, Mr. Floyd's blood CO level should be tested. So the state received that part of Dr. Fowler's report back in February. Is that correct?
That's correct, Your Honor.
All right. Anything else, Mr. Blackwell?
So he said it should be tested and the state didn't test it. That's negligence on their part. I wouldn't let it in.
Before I turn to Mr. Nelson.
Your Honor, no, nothing
All
further.
right, thank you. Mr. Nelson. Mr. Nelson.
Thank you, Judge. Yes, for the record, in terms of rebuttal, a couple of things I would like to address. First is this new information that was just received. I would, for the record, indicate that I received these test results at 7:53 this morning. As I understand it, Dr. Fowler is on an airplane and having some difficulty reaching him at this particular moment. I have spoken with other people from the forensics panel. They're looking into these things. Nevertheless, Your Honor, the point of this is that this issue was specifically raised, as the court points out, back on February 22nd, some 20-some odd days, or 40-some, 60 days. I don't even know how long it's been. I'm a little time deprived at this point. The point being is that the state has had more than sufficient notice. Dr. Fowler is opining that this could have played a role in his report. He says and suggests that for completeness, it should have been tested or should be tested. The state retained and continues to retain any blood samples. They are not within the control of the defense. The state has had ample opportunity to rebut any suggestion. As far as the information relevant to the Mr. Blackwell references in terms of the oxygen levels, the 98% oxygen levels, what Dr. Fowler testified to yesterday was how you can't rely on the oxygen levels because it's the carbon monoxide binds to the oxygen and it can give a false reading. You need this testing, the hypoxia oxygen testing.
Great point.
So the bottom line is that this is information that has been within the state's control. The state has had ample notice that this could have played a part of Dr. Fowler's testimony. It is incredibly prejudicial to the defense at this point, now after Dr. Fowler has testified and left the state, to bring forth evidence. Again, the jury being the trier of the fact. Dr. Fowler was pretty clear. He was not saying that this was the cause of death. He's simply opining that it wasn't considered by the state. And apparently it was considered to be a ridiculous concept by the state of Minnesota that they didn't think to test it. Since this trial has started, in addition to this new evidence, the state has had multiple conversations with a city employee about the vehicle itself. They've gone and taken pictures of the vehicle. Again, all of this they've had ample opportunity to do, but this is what they're doing in the middle of trial, even though they've known for a long time that this was an issue.
All those points are extremely valid, and the judge should not cut the state of. The judges tend to usually always cut the government slack, though. So I don't know how he's going to rule, but I think it's bullshit if he lets it in.
I did receive also last evening a summary of Dr. Tobin's anticipated rebuttal points. Three of the 4 points I do not see as proper rebuttal, but we can address that later.
Well, let's address that now, as long as I'll ask the state to respond to
Sure.
something other than your carbon monoxide issue.
The fact that he wants to discuss the specifics of the rebuttal tells me he's already made up his mind he's going to let him testify. If he made up his mind that he wasn't going to let him testify, he wouldn't want to waste time on hearing the points. So I think he's going to allow it.
Yep. So last night I received a one-page memorandum referencing a conference that they had with Dr. Tobin. It's date stamp 50417. They identify 4 areas of potential rebuttal. The first being that Dr. Tobin will testify regarding the significance of the hypoxic changes from a physiology and clinical standpoint, including his conclusion that the anoxic seizure is not indicative of a primary cardiac event based on the timeline of significant events. I believe that Dr. Tobin has already extensively testified as to his opinion of the significance of the anoxic seizure. I mean, that formed a large basis of his testimony and how he concluded that. Now, the fact that there is a differing opinion that it's a cardiac event instead of a hypoxic event that's the nature. Again, state has had ample notice. It's not rebutting. It's just simply reintroducing what Dr. Tobin has already testified to extensively.
Good point.
Well, my recollection of Dr. Fowler's testimony is that he agreed that it's a hypoxic reaction. But it's just the mechanism. I think we're talking about the mechanism. Was it due to a positional asphyxia
Correct.
versus a cardiac arrhythmia? But I think they all agreed that it was a myoclonic seizure as a reaction to hypoxia.
Agreed, Your Honor, but the mechanism being the point of what Dr. Tobin has already extensively testified to.
Right.
And the fact that Dr. Fowler had a different opinion, this is not proper rebuttal because it's already been testified to at length. What the mechanism of the seizure was has already been opined by Dr. Tobin.
Okay.
The second area...
So, and the reason he's arguing this is you can't call it a rebuttal if you're just repeating testimony. And that's what the prosecution has done the whole time, is they are repeating the narrative, showing the same videos and showing the same picture and trying to brainwash the jury that if we repeat a lie long enough, it becomes the truth. So that isn't proper rebuttal.
That Dr. Tobin has indicated is he said Dr. Tobin will testify regarding the scientific research supportive of his analysis that showed how the hypopharynx can be narrowed. Again, I believe that he has already extensively testified to his position as to the narrowing of the hypopharynx. Whatever this additional research is, I have been provided with a single journal article relevant to the treatment of COVID patients. That was provided to me last night as well. If it's limited to that single article, I guess that could be construed to be additional evidence. But again, Dr. Tobin extensively testified as to his view of the narrowing of the hypopharynx. The third area is what is written as follows. Dr. Tobin has reviewed and will testify as to his analysis of the 2 studies of that Dr. Fowler cited regarding outdoor exposure to carbon monoxide. Dr. Fowler testified that Mr. Floyd could have had a level of 10 to 18% carboxyhemoglobin as reflected in the slides disclosed on 413, and that in his opinion this level could have contributed to Mr. Floyd's cardiac-induced death. Dr. Tobin will rebut this analysis and provide his opinion that based on lab tests done at the emergency department, Dr. Fowler's analysis does not hold. So this email being sent at 4:53 p.m. last night, or approximately 5 o'clock last night, suggests that Dr. Tobin may have seen these test results, or the test results done at the emergency. There's no indication, is it these new test results or is it some other test result? Nevertheless, it's our position that these new test results should not go in front of the jury, first and foremost. And second, if they were, I would be moving for a mistrial based on this. Because again,
you got to be careful about threatening the judge with a mistrial, because judges don't like that. But, you know, you got to put the judge on notice that judges don't like to be overturned. So, and a mistrial isn't an overturn. I mean, a mistrial is normally something inappropriate that's done. And I mean, I don't know if you can file an appeal over a mistrial denied. I assumed you can. I mean, I think he can file an appeal because he didn't change venue and there was riots in the area in the middle of the verdict. And they had to sequester the jury in the middle of the riots because another black man was shot, and he shot a black man, and that's what this whole trial's about. So, I mean, I think that's an appealable offense, but we'll see.
And the state has had ample notice. Finally, Your Honor, the fourth paragraph reads, in his report regarding the size of Mr. Floyd's heart, Dr. Fowler cited 2 studies, the Molina and DeMaio study and the Northwestern study from 2021. However, Dr. Fowler did not cite the Mayo study that he referenced in direct examination, and he did not offer the opinion that Mr. Floyd had an enlarged heart. Dr. Tobin will clarify the facts underlying these studies and their application to Mr. Floyd. Again, this is the very nature of our system, right? There's an opinion and there's a counter opinion. That Dr. Tobin has already cited this study. He has talked about this study. He acknowledged the existence of the other studies. So this is not proper rebuttal because it's already been testified to. They're trying to recreate and get Dr. Tobin in front of the jury again to talk about things he's already talked about. The CO2, fair enough, right? To some limited extent based upon, Dr. Fowler's testimony.
Mr. Blackwell, let's talk about those other, aside from the lab tests, those 4 points that the state is seeking to present rebuttal.
Obviously, Your Honor, we wouldn't be having any of these discussions this morning had there not been new opinions from Dr. Fowler raised from the stand. And one of those new opinions, and one which I think I was objecting to at the time.
You don't get to control the opinions of the expert witness. So what if it's a new opinion?
Was his discussion of the Mayo study. This had to do with the whole issue of the enlarged heart, the cardiomegaly. And he had disclosed to us his reliance on Molina and DeMaio, and also the Northwestern study. That was in his report. And as Your Honor well knows, the whole point of having reports and disclosures for both sides is so that both sides have notice for what's going to be testified to on the stand. So he testified about the Mayo study anyway. He expressed his opinions about the Mayo study. It was a free kick at the goal because we didn't know that he was going there.
And what study again? Could you spell that one? Because I'm mixing up DeMaio and...
Yeah, the Mayo study is M-A-Y-O. It's as though it should be pronounced Mayo.
Okay.
And what Dr. Tobin would talk about would be that particular study and the fact that in the opinions that Dr. Fowler had presented in his report, he didn't offer the opinion that Mr. Floyd had an enlarged heart. He offered it from the stand. He didn't offer it in his report. And had we known at the time from the disclosures that that's what he was going to testify to, then we would have addressed it during his testimony, during his direct, when he was here before.
But let me ask you. So what specifically do you want, Dr.
So this is why one doctor did a 5,000-page report or 500-page, whatever his freaking report was. And this doctor did a 31-page. See, the prosecution is paying for all these reports because everything they put in a report, they can say, hey, we disclosed to the defense so we can talk about anything. When this doctor for the defense did a 31-page report and disclosed it to the prosecution said, hey, he talked about things that's not in his report. We would have prepared for it, but we didn't know he was going to talk about it. So the defense withheld stuff from us. And you know what? I think the defense should be able to withhold stuff. I don't think the defense ought to have to discover, to be honest. I mean, the government gets everything stacked in their favor. You know what? If your case is good enough, and if you did the right enough investigation, why do you need to worry about what they did? Put your case on and prove your freaking case. But, I ain't the king or the judge, so.
Dr. Tobin to testify to regarding an enlarged heart?
He will simply testify that if you then look at the overall studies, including the Mayo study that we've been talking about, that Mr. Floyd's heart weight does not fall within a range.
Okay, at this point right here, you never believe what he's going to say. See, he goes, he's simply going to talk about the enlarged heart. That means they're going to keep him on the stand for 15, 20 minutes and show a bunch of pictures. If the defense is on this, he go, Your Honor, look, I'm not in favor of any of this, but if you allow it, I want the scope limited to what the prosecution says. So I would like their questions in writing, kind of like I did with Mr. Hall, and you didn't let him testify. I would like their questions in writing so I know exactly so I can address it. I don't want to give them the highway and the freeway to go wherever they want. That's what the defense ought to be doing.
That is abnormal. So he'll talk about the the broader sort of pool of studies in the framework of discussing the Mayo study that we had learned about, at least that Dr. Fowler was going to rely on in his testimony.
I guess one question I have is, he's the pulmonologist. He's not the cardiologist. Are you recalling your cardiologist to talk about the enlarged heart and give an opinion about an enlarged heart?
No, Your Honor, just the pulmonologist.
Okay.
And obviously there's a cardiopulmonary system, and they both kind of operate kind of hand in glove. So we felt...
That means we can get one guy and we can't get the other guy. That's what that means in lawyer talk.
Frankly, in the interest and respect in Your Honor's admonition, that we try to be focused substantively and temporally, to simply call one person to talk about this and not multiple ones.
All right. Okay.
Oh, you're doing the court a favor by calling this guy now because it's multiple. Oh, isn't that nice of you? I'm glad you're so concerned about that. You're not concerned about lying and winning.
What about the other?
On the issue of the hypoxia, for the first time from the stand, we heard from Dr. Fowler that an anoxic seizure was evidence of a primary cardiac event. Your Honor is right. And what Your Honor had understood, that both sides do understand kind of what happens when you have an hypoxia event and how one passes away. What we have not heard was Dr. Fowler attributing it to a primary cardiac event. That was not in this report, and it was disclosed for the first time from the stand. And as well as relates to the hypopharynx, that was crystal clear from the stand, that Dr. Fowler said, having heard Dr. Tobin testify, I went out to canvass the literature and I found nothing there supportive of his theories for somebody who has studied the science of breathing for 46 years. So what Dr. Fowler would testify there is what is the nature of the research in that respect, in direct response to the new statement from Dr. Fowler from the stand.
Let's talk about the opinion regarding the carbon monoxide effect and Dr. Tobin's opinion, which would appear to be within the scope of his expertise as a pulmonologist. But is it going to be solely talking about the lab tests?
It is solely talking about the carbon monoxide content of his blood, Your Honor. I don't want to try to answer the court's question as clearly as I can.
Oh, go ahead.
It isn't just talking about the test
You've been trying to confuse the juror and the judge. You can't say a straight freaking word because you're making it up as you go. This guy has zero credibility to me.
results. The test results are subsumed in it. But the bottom line of what he's talking about is what is the evidence as to whether or not the carboxyhemoglobin content, the carbon monoxide content of his blood could have been in the range of up to 15%. And he's saying that based upon the medical evidence available, that was available to everybody, looking purely at the oxygen.
What was available to everybody?
The oxygen saturation content of his blood.
Okay.
And contrary to counsel's comment on the science, the way that the oxygen saturation works, we have hemoglobin, so either the oxygen is going to combine with the hemoglobin or carbon monoxide will. And if carbon monoxide has bound to it, then you can't have an oxygen saturation of 98%.
No, I understood the testimony.
So that is what he would speak to. The test results are merely corroborative of that, because the test results show a specific testing for carbon monoxide itself, and it is simply derived from looking at the oxygen saturation content, which is at 98%, and therefore the most carbon monoxide could have been is 2%. So it is addressing the same issue from the two different perspectives: oxygen saturation versus actual testing and the test results of the carbon monoxide itself.
Well, I agree with you that if the tests had been disclosed earlier before Dr. Fowler testified, there'd be no problem with putting that in his rebuttal. Probably there would have been no need, because Dr. Fowler would have been advised of the results and testified accordingly. So there would have been no need for rebuttal. So, but other than that, so are those the four topics, though? Did counsel set those out pretty clearly?
Yes, Your Honor.
All right, thank you. All right. First of all, in dealing with these lab test results, I find that Dr. Fowler's report gave sufficient notice to the state that the carbon monoxide that potentially was in George Floyd's blood could have affected cause of death. I read page 15 of his report, which I don't have at my fingertips at this point, that basically they said, Dr. Fowler came right out and said it should be tested. That gave the state notice with sufficient time in February to either test the samples that are still there or to dig a little deeper. It's just by serendipity that Dr. Baker calls the state and says, oh, by the way, it does exist. It should be in there. It seems to me very odd. I'm not claiming any bad faith on the state's part, but it seems odd at Hennepin County Medical Center, when they're asked to turn over all their records, that they don't include records that maybe are just buried a little deeper. I think
good for you.
Their response to the subpoena was probably insufficient in and of itself. And they should check their standard operating procedures so that in the event this happens again, that they will supply all the information they have. But in any case, the defense gave notice that this was going to be an issue, and specifically talked about testing the sample. The state had sufficient time to investigate and disclose, to, even if it's just because Dr. Baker called the state and said, we can actually find this, at 8 o'clock this morning, when the defense expert is done testifying, has left the state. It's untimely to give the notice, and it prejudiced the defense by the late disclosure, even if it's not. The late disclosure has prejudiced the defense. It's not going to be allowed. So Dr. Tobin will.
You go, boy! He threw the defense a bone.
Will not be allowed to testify as to those lab results. If there's anything he wished to add about carbon monoxide as far as environmental factors, but if he even hints that there are test results that the jury has not heard about, it's going to be a mistrial. Pure and simple.
Whoa, man. Let me tell you something. When a judge tells you that, and the reason why he's telling him that, because he knows the DA will try and slip this in or infer and get the witness to mention this test result. And the jury didn't hear it, and it'll create questions. And he warned him flat out, it will be a mistrial if he brings it up. That's basically telling the prosecution, you better tell your witness at no point in time and under any circumstances that he mentions a test result that y'all have and we're not letting them see it. Because the jury doesn't know that they're not seeing it because the state dropped the ball. So they will just do a mistrial. And nobody wants a mistrial after all the witnesses testified, especially on this case. But you know what's going to be funny? If they put that witness up there and he implies about the freaking thing, you're going to see shit hit the fan.
There are test results that the jury has not heard about, it's going to be a mistrial. Pure and simple. This late disclosure is not the way we should be operating here. In that case, Dr. Tobin may testify as to carbon monoxide if he sticks to the environmental factors, and as a pulmonologist looking at the videos, for example, and seeing Mr. Floyd's location and not knowing whether the vehicle is even on or not, which the state brought out in cross-examination. All those factors you can talk about environmentally and what the likelihood is that it would affect his carbon monoxide concentration in Mr. Floyd's blood, that's fine. But nothing about these lab test results that were just disclosed 8 a.m. this morning after the defense expert is done. With regard to the DeMaio, I will allow I have a little concern that we're having a pulmonologist opine whether it's an enlarged heart or not. But given his background, which, as I think Mr. Blackwell appropriately stated, is a cardiopulmonary system, it is a system, and I think he has some expertise in the function of the heart and its relation to the lungs. And so I think it is appropriate that he be allowed to opine whether or not the heart was enlarged or not, based on those studies, and specifically responding to those studies. As far as the scientific research, the defense did bring up as a new issue whether or not narrowing of the hypopharynx is supported in literature, and Dr. Fowler said he did a check and he didn't find anything. I think it is permissible that Dr. Tobin be allowed to come and say, since Dr. Fowler's testimony, he has done his own search, or he relied on this, and there is literature, and he can talk about the literature in a summary fashion. With regard to the hypoxic seizure, it was pretty clear from Dr. Tobin's testimony that he had an opinion that there were movements of George Floyd's legs, that those were myoclonic or anoxic seizures due to the lack of oxygen. Dr. Fowler did not really dispute that. He also indicated that it was a lack of oxygen to the brain that causes such seizures. The only difference between the two was the mechanism. Did the lack of oxygen, was that caused by positional asphyxia versus cardiac arrhythmia? And as I recall, Dr. Tobin excluded cardiac arrhythmia or a cardiac event as the cause of the lack of oxygen. Since he has excluded a cardiac event as the cause of the lack of oxygen, that evidence is already in the record. I don't have to remind both sides that the purpose of rebuttal evidence is not to restate what has already been testified to. It's to bring up new evidence to rebut something that came up in the other side's case.
That's good that he said that, because now the defense has a good objection. As soon as they start talking about shit that's not directly related to the rebuttal, he can object.
Accordingly, as to the hypoxic seizure, that's not going to be allowed to be discussed, but Dr. Tobin can talk about carbon monoxide and the likelihood of a high carbon monoxide reading based on environmental factors, if he wishes, because that was gone into a great extent. And finally, the reports, and he may opine whether, in his opinion, George Floyd's heart was enlarged or not. Do we have pretty much the ground rules set?
Just one question for clarification on the carbon monoxide. There were test results that existed before the ones that are at issue from last night / this morning. What Dr. Tobin, these are the ones that relate to the oxygen saturation. So that was known before last night. And so I haven't talked to Dr. Tobin this morning about what he's going to say or when. I might ask the court for a few minutes before we start. But what he was able to come to last night without saying anything at all related to these test results at issue was we had the results already, both sides do, on the oxygen saturation in his blood from May 25th, 2020.
Well, let me ask you this. Is his opinion going to be that when the oxygen saturation levels are this high, that precludes high CO, because a high carbon monoxide reading would depress the saturated oxygen?
That's correct. They are would be inversely related. So a high oxygen saturation
would indicate a low carbon monoxide.
Yes.
Mr. Nelson?
As I understood Dr. Fowler's testimony, at lower levels of carbon monoxide, because the pulse oximeter it's not going to differentiate based on the color of the blood. between oxygen and carbon monoxide.
This is the bright cherry red testimony.
Right.
I think that's appropriate cross, but I think if that is in fact Dr. Tobin's opinion that these oxygen saturation readings, which have been disclosed earlier, would indicate a low carbon monoxide reading because they are inversely proportional, and it's appropriate, however, to say those readings are based on pulse ox, color of the blood, color of the fingernail, and the bright cherry red essentially confronting him with that testimony. I think it's appropriate cross, but it does not preclude the state from recalling Dr. Tobin for that purpose.
Yep, that's the clarification, Your Honor.
All right.
Thank you.
Yeah, that would be permitted. All right, anything else before? And you want a few minutes to talk to Dr. Tobin?
If I may, Your Honor.
Why don't we start up at 10 o'clock? I assume he's close by. You can do it quickly, Mr. Blackwell.
I was hoping for a few more minutes.
I think since the defense is going to rest and we'll proceed directly to Dr. Tobin, are we calling anybody else?
No one else, Your Honor. And if we could have the 10:15.
10:15 it is. All right, 10:15 we'll reconvene. Thank you.
Okay, so you got the judge's ruling. We'll see how this plays out. If the defense rests, the case would be over, and, they would be releasing the jury until closing arguments on Monday. So now we're going to hear another testimony. All right, we'll end that there and wait for the testimony.